Yes, Thursday outside, it has to be said, in Brisbane. I am Chris Hynes, former Commissioner, Body Corporate Community Management, Strata Consultant, Hynes Legal. With me, as always, on a Thursday for our webinars, Frank Higginson, Partner, Hynes Legal. Frank, welcome.
Hello, Chris. Hello, everyone, yet again.
We've gone polos today. So combo of formal and semi-formal, I suppose. As always, everyone, don't forget to subscribe so you can find out what we're doing and when. If you've got questions, feel free to put them up live today and we'll try and get through as many of those as we possibly can. If your question's a little bit more detailed, and we did actually have had a couple of those recently, could I ask you to please put it on the form link that we are just about to put up in chat? That's a better way of getting in touch with us for more complex things. Today, we represent, and all of the ways in which represent or represent, depending on your vernacular, happen. So when it comes to proxies, powers of attorney, representatives, nominees, Frank, we get hit up about that sort of stuff all the time, don't we?
A lot. And it's sort of that people, I suppose, getting upset about other people stacking things, putting patsies in, puppeteers, all that sort of stuff. And it's an interesting one always. And you see the legislation, I suppose, deals with a range of different styles of the ways to have other people represent you with limitations around certain types of it. And I suppose, and this is very much a BCCM conversation we're having today. When you go to Bugta, there's nowhere near the limitations that BCCM actually has. And I remember when I was a little whippersnapper and starting my legal career 30 odd years ago, the phrase that got used a lot at that point in time in the early 90s was proxy wars and proxy farming, because what was happening under all the schemes which were regulated by Bugta then is people running around getting proxies forever and basically creating a voting block which no one could overturn. And I suppose BCCM went very specifically at a couple of those style of things to prevent that from happening.
Yeah, and look, that sort of comment about voting blocks gets raised quite a bit. I've heard it quite a few times where people have complained about how unfair it is that there's a voting block and not liking the idea at all of any kind of representative voting on behalf of somebody else. And I get it up to a point. But having somebody exercise your vote or exercise your rights and responsibilities is 100% a feature of government and governance right around the world, regardless of what it is. Happens in federal parliament. If it's good enough for parliament, I think it's good enough for body corporate, because there are many reasons why somebody cannot be present for a meeting. There's this thing called COVID that you might have heard of, which has some impact upon that. And so we get it, we get the frustration, but it's having a representative on behalf of somebody is a fact of life in a body corporate, but there are regulations on how it works. We're going to go over the four main ones today: proxies, powers of attorney, something called a representative, and then a nominee, and then, as always, we'll give you our takeouts. Electronic voting, Frank, might play a part in regulating, mightn't it?
Well, that's where, and it's really interesting because this is still sort of playing out in the strata industry. I mean, old regime, new regime, 1 March we get our new modules. Sort of the old regime wasn't quite as overtly supportive of electronic voting as what the new regime is. Still, we're seeing some bodies corporates that haven't adopted it. And I think there's probably, like I suppose with any innovation, there's early adopters and the average and then the late adopters and all the rest of it. What electronic voting should do is ideally remove the need for some of these styles of representation. And I suppose, Chris, to sort of back up what you were saying before, as much as some people, don't like the fact that others can appoint representatives, the reality is that if I own a lot in the community title scheme, what I choose to do with my vote, including not cast it, is completely up to me. And that's so right. Denying me the right to choose someone to represent me is almost a little bit unfair in itself. But electronic voting, and anecdotally, what I've been getting as I talk to body corporate managers, is that there is an increased participation rate by owners when you use electronic voting, because previously, you get your hard copy paper, you fill it in, you've got to potentially go get your own envelope, your own stamp, find your way to a post office and send it back, and it's still then got to get back to the secretary in time. And mind you, I haven't seen the tech. Actually, I have seen tech examples. If you can tick yes, no, yes, no, yes, no on your phone, then it absolutely will mean more people will participate in decision making, which is what these provisions were designed, I suppose, to allow, when people couldn't get there personally.
That's right. That's a really good point, actually, Frank. And the other point we make before we talk about proxies to begin with is that when it comes to a member of a family, there are some inherent rights, aren't there, Frank, about being a representative? Yep.
Absolutely. So family members have an automatic right to nominate for committee without, family members of a lot owner can nominate for committee without any other paperwork at all. Don't need to be a power of attorney, don't need to be a proxy, it's statutory. Although, interestingly, when we were just having a quick chat about this beforehand, something that surprised me a little while ago, I had to go and look it up, in-laws aren't family for the purposes of the module, which I found slightly surprising, but there you go.
Neither are grandparents, Frank.
Ah.
Neither is aunt and uncle. No, it's a very narrow definition of what family is. And it's quite different to what the broader definition of family usually is in other statutes too. So just keep that in mind, everybody. Look, let's rip straight into proxies then. I think this and powers of attorney are the most common forms of representation that you find, and the two things are very different. We're going to explain the essential difference between those in a little bit. Proxy, think about the proxy as me actively deciding that somebody else is going to take my place for something. There are some different requirements, whether it be a committee meeting or a general meeting. I'm going to put up the link to the standard module gives the overview of that. Proxies are absolutely used for counting quorums, so that's another really important point to bear in mind. And here's a fun fact. If the body corporate resolves by special resolution, it can prohibit the use of proxies altogether without any further reference. Now, that's something I don't think a lot of people understand too well, that if you're in a body corporate and you are dead set against proxies, or you think that proxies are having an undue influence, there is the ability to ban them. But given they're already having an undue influence, it's hardly likely that resolution is going to get up.
Interestingly, they've excluded, you can't use proxies to vote on a resolution about the prohibition of proxies.
Which is fair enough. So just keep those points in mind, I reckon. Frank, committee meeting, use of proxies. What happens there?
Well, there's lots of things, I suppose. So when you look at general meetings, I wouldn't quite say it's a free-for-all, but it's not quite as many limitations as there are at committee level. So, like, to me, I think one of the other things that's really important with proxy use is that bodies corporates can prohibit them absolutely, or prohibit them from being used on certain things. So it can be, a bit like spending limits. You can change spending limits overall, or you can change spending limits for a particular program or process. So, at committee level, I suppose some of the golden rules are that if you are going to appoint a proxy at committee level, it needs to be another member of the committee to start with. So you can't appoint someone from outside that group of people that were voted in at the AGM. You can only appoint a proxy for 2 meetings throughout the course of that particular year. And I suppose that's, it would be interesting to go back to the reading speeches on these, Chris, in, where are we? 1997, to see the basis for it. But I'm assuming that really is the government saying to people, if you've put your hand up to be on the committee, then you should participate in the committee decisions and not just hand your proxy over to someone else and be absent all the time. And for whatever reason, for the treasurer or for the secretary to appoint a proxy, it requires the approval of the committee. So an ordinary member or the chairperson can seemingly do it as they see fit, again, subject to that 2 proxy limitation. But secretary or treasurer can only do it if the rest of the committee consent or agree to it. So they're probably the differences from and general meeting, I suppose we'll talk about in a minute, but there's some of the specific rules around committees. So it's committee members, if they can't get there. So if Chris and I, we're both on a committee and Chris can't get there for whatever reason, he can give me his proxy. I can't hold a proxy for another committee member then. You can only hold one. So that in effect at that meeting, I'm carrying 2 votes. Chris is in attendance by virtue of my attendance, and I've got two votes on whatever the committee issues of the day are. And I suppose it's sort of, we get lots of regular type of inquiry. I wouldn't say we've had too many disputes over that side of committee governance, and maybe because...
I was going to say, Frank, it's probably more general meeting stuff, isn't it?
Yeah, because the legislation's pretty clear. Like, there's not much grey around what you're allowed to do or not to do with respect to committee proxies.
I think that's right. General meeting, though, there's a fair bit which applies to the use of proxies at a general meeting. So proxies are not allowed for elections, secret ballots, or engaging a body corporate manager or a contractor. So you look at that and you go, well, okay, perhaps the most important business that gets conducted at a general meeting, you can't actually use a proxy for. So immediately the legislation is creating that distinction there, isn't it? There are important, super important things and things with less. And for those super important things, we don't want somebody who holds a proxy casting a vote on that. It has to be the people who are involved. Then there are also caps on the number of proxies. So you can hold 1 proxy if there's 20 lots or less, and then you can have a 5% cap if there's more than 20 lots. That used to vary slightly depending on whether it's accommodation or standard module, but no longer. And here's a fun fact for everybody watching out there. There is a financial penalty applicable for the misuse of a proxy. So for example, if you purport to hold a proxy and you don't, so you say, for example, you faked a proxy, there is actually a financial penalty under the BCCM Act for that, one of the few instances where financial penalties actually apply. So I think the takeout there for a general meeting, legislation makes some pretty strict obligations, doesn't it, Frank, about proxies?
and those cap numbers were, when they arrived, I think the government to say to people, you can't proxy farm and you're not going to be able to use them for this. So stop, which it did.
You can proxy hobby farm. No. But not proxy farm.
2 acres at Sanford, that's it.
Yeah, proxy harvest, maybe that's what they meant. Let's move on to powers of attorney then, Frank. So I know from, again, when I was commissioner and in this role, I have had a lot of people confuse the 2 things, but use them interchangeably, but they're not the same, are they? What's the difference, Frank?
No, well, there you go. So I'd say a proxy from a BCCM perspective is a representative instrument under that piece of legislation itself. So there's no actual proxy laws, you know. So I suppose you go to company constitutions, you go to clubs, you go to not-for-profits, they've all got their own constitutions and they've all got their own rules around proxies. And mate, here's an interesting one. I looked up the constitution of my golf club the other day, come AGM time. So old school, this is written 100 years ago, you can only vote for office holders between 9 a.m. and 4 p.m. on the day of the general meeting in person. So you can't email in a ballot, you can't appoint someone else to do it, because I was looking to appoint someone to do it for me because I couldn't be there because we're on holidays. But anyway, so proxies are really creatures of the organisation. They're not statutory. Power of attorney is not that. So power of attorney, typically from a mum and dad perspective, is where each gives a power of attorney to the other. So if you're doing a will, ordinarily you do a power of attorney at the same time. And that power of attorney now can extend to financial matters, always has, and now personal health directions and that sort of thing. And probably in the next 24 to 48 hours, making decisions on voluntary assisted dying or otherwise. Haven't actually read that legislation, but they're in the throes of doing that right now. So a power of attorney is a much wider document, and that actually has government legislation around it. So a power of attorney, again, typically husband and wife, obviously family, and they're documents of significant trust. as a rule, because if you give someone a power of attorney in relation to your financial affairs, they can walk into the CBA and draw out 250 grand and do what they want with it, as much as that might be a breach of their fiduciary duties. But anyway, so in a body corporate context, where powers of attorney started appearing was lot owners appointing individuals to be a power of attorney or an individual, and effectively proxy farming by a POA. So that POA, the power of attorney, can be limited to also, by the same token, it can be as wide as you want, it can be as limited as you want. So the power of attorney could be limited to just voting on motion 13 at the annual general meeting of Hynes Towers in 2021. So you can really confine it as well. So that's really the main difference between the two. And powers of attorney as a means of representation weren't necessarily wiped out with our new modules that arrived in March, but they were substantially restricted. So, and I think I've been responsible for changes of legislation 3 times now, and this is my 3rd one. I think my biggest one, I went to a meeting with 96 powers of attorney. So it's fair to say our client got what they wanted at that meeting. But now it's limited to if you're a family member, again, of the person who's owns the lots, then you can hold more than 1 power of attorney. But other than that, it's 1 power of attorney per person.
Yep.
So that's really sort of winding back powers of attorney to be, they can still be used to vote on anything. So they're not limited in the sense of proxies where you can't use them to vote on election of committee. But by the same token, proxies, you're allowed sort of that 5% powers of attorney are capped at 1. End of story. No ifs, no buts.
Right. There's when it comes to powers of attorney, Frank, it's a different kettle of fish again when it comes to developers, isn't it?
It is. So developers, for anyone who's bought something off the plan, you will see that developers have a statutory right to require buyers to appoint the developer as their power of attorney for basically 12 months after registration to put into a place what they've disclosed to buyers in relation to the affairs of the body corporate. So bylaws, management rights agreements. And normally what happens is registration happens, the body corporate's created, the developer, because they haven't sold any lots yet, they tend to push through at the first EGM all of the things that have been disclosed, but things can happen after that when they start settling lots. So usually what happens, and what the BCCM Act specifically allows, is that if it's disclosed to buyers and it's a contractual obligation, then the developer can require buyers to give the developer that control for that 12-month period after settlement. And it's really important that the power of attorney isn't unlimited, like it's not extending to banks and health directions and all that sort of stuff. It is usually relating to purely body corporate issues. Yeah. And that is disclosed in the contract documentation. And we get this a little bit, actually, and just quoted on one this morning, actually, where a developer's coming back to do something after the event, and the body corporate committee, which is now in control, has said, do they have the right to do it? So, well, it's going to depend on their power of attorney and the interpretation of what those provisions are with respect to what it is they're trying to do. Because quite often there's this mistaken assumption that developer's power of attorney gives them the ability to do whatever they want. That's not the case. Mm. They can only do what the power of attorney itself gives them the right to do. Mm. And a body corporate's entitled to see it. If someone says, I'm voting under a power of attorney, well, where is it?
Indeed. And that's going to be, we'll get to that kind of stuff a bit more in the best practice tips right at the end. So as Frank alluded to there, these laws changed from the 1st of March, and I think it's fair to say the clear intention of government was to try and restrict power of attorney usage in the same way, not entirely the same, but in the same way as proxy, trying to find ways to limit this idea that the powers are all concentrated in a particular group of people. So I guess we need to wait and see to see if those changes are going to have the desired effect or not. Yeah. We kind of take the view that human nature being what it is, people will probably search fervently for other ways of getting
And
it done.
yeah, and sort of, it's sort of 9 to 10 months in the Commission's office at the moment from start conciliation to finish with adjudication. So any arguments about the new regulations, we're not going to see until early next year in terms of decided cases, usually.
Yep.
Whether interim orders justifies some speed or otherwise, but yeah.
Probably, Frank, that's probably right. Before we move on to representatives, question from Pat. Thank you, Pat, for watching. If an owner gives me her POA and then she is elected in her own name onto the committee, can I attend as a committee member in her place, subject to the terms of the POA?
Good question. My vote would be no, but I've got no legal basis to say that other than off the cuff. So it's an interesting one. It's sort of like, to me, where they've certainly got to, if you're going to look at the parallels of Proxies, what they're doing there is keeping the committee members who were elected at the AGM in-house in terms of appointing other people. So they're not allowed to appoint an outsider to come into the committee meeting. You can only appoint another committee member as a proxy for the purposes of voting. So if you're going to use that as the statutory intention to keep the people that were voted on to be the decision makers, then that power of attorney example wouldn't allow that on. And the other thing is that perhaps one way to look at committee membership is it's a personal appointment in one sense, not necessarily delegatable by virtue of that same sort of proxy type stuff. So haven't been asked that question before, not aware of an adjudication on it. But yeah, I think the committee member is Chris appointing me as his power of attorney and me going in his stead, I don't think is really what the legislation is driven at, as much as I don't think it expressly prohibits it either.
Yeah, I think I more or less agree with you on that one, Frank. Let's talk representatives then. So this is different again. The legislation provides for someone being a representative. And this, the arrangements around that are very much thrown back to the Secretary. And the Secretary must be satisfied of that representative's so-called representative capacity. So that's in the standard module, section 101 4A. Literally, I think, Frank, anyone can be a representative.
Yeah, this is one that's not. I've never really seen it used or dealt with. It's not. There's other sections that talk about representatives being mortgagee in possession or liquidators and that sort of stuff. This is anything, and not by virtue of any particular instrument of appointment either, like a power of attorney or a proxy.
That's right. There's also the ability for a representative to attend a committee meeting. And we actually think that it's in some cases you can both attend. Yep. You still need to comply with the obligations that go around a non-committee member attending a committee meeting. This is not an area we see a huge amount of. It has to be said.
No, and mate, I'd probably back up to the proxies. I think if you appoint a proxy for a general meeting, both you and the proxy can go.
Yep.
So to me, that's representatives probably consistent with that.
Okay. Question from Hatlow Heights. Thanks for tuning in. Can an interstate lot owner POA to a long-term tenant for nomination on the committee using the general POA supplied by the Queensland government? If so, how to word it? That's a legal question, Frank, isn't it?
Well, it is, and I think the answer is going to be yes. So if I own a lot, I can appoint whoever I want to be my power of attorney, and that power of attorney can give them the right to nominate for committee. I suppose how to word the POA, that is definitely legal advice. I'm not going to go there with that. I don't think it's complicated, but in the context of one of the things that it's very easy to do is sort of just fire off something now, but it's going to depend on circumstances. Always does, always will be. I suspect it's pretty straightforward, but the standard POA document, if you Google just Queensland Government's general power of attorney, that form is going to be completely fine for all of the things we're talking about today.
I think, remember though, as we said, I think we said at the start, if you're in the position, and this will be part of our best practice as well, if you're going to be in a position where you're asking somebody else to exercise your rights, remember that you are signing over your right to do that yourself, effectively. So you're getting somebody else to do it. You need to be satisfied that whoever else you're asking to do it is going to do the job, basically. Not such an obvious thing, I would have thought. And then finally, and pretty quickly, nominees. So here we're referring, Frank, to a corporate nominee. So in the standard module, that's section 101, subsections 6 to 8. And so basically, that could be anybody who the corporate entity nominates, and can be in the alternative. So Chris or Frank. Yeah, and don't forget that this is quite separate to corporations law. So corporations law applies to the directors of companies, and they have responsibilities under that legislation as well. But here we are talking about ABCD Proprietary Limited being a lot owner. They nominate, it would frequently be a director of the company, but not necessarily, to be their representative in some form.
Because companies themselves can't vote. And companies can't represent, East Coast, West Coast, all that sort of stuff. Company can't be on a committee. Only the representative of the company can be. So if you haven't got, so if a company's on the roll and they haven't nominated a corporate nominee, the company loses the right, in a sense, to representation or the ability to nominate for committee.
Yep.
And actually, I might answer Pat's question there, Chris, that popped up. The distinction between Pat's question and the question from Hatlow Heights is that in Pat's case, Chris was nominated to committee and then appointed Frank as his power of attorney and wanted Frank to go on. In the Hatlow one, Chris owns the lot. Chris appointed Frank as the power of attorney and Frank nominated to go on committee. So I've been elected as the committee member, as opposed to your friend who was elected as the committee member and tried to sub someone else in. So there's the distinction.
Yep. I think different kettle of fish. Let's talk about some best practice and some takeouts out of all of this. And I think there's a few, but in this case, it varies according to your position, I reckon. So if you're somebody who has or is thinking of having someone represent you, or indeed you're thinking of harvesting, there's that word again, support by getting proxies, POAs or others, well, think pretty carefully about that. As we said before, do your sums, make sure you actually have got the right numbers of those. Seek advice. Consider if there's an easier or a better way to achieve your outcomes than this process. And then I think, Frank, the big one, check that the representation that you are thinking of using is actually going to do the job that you want them to do, because as we have established today, there are restrictions.
Absolutely there are. So there's no point, going and gathering a whole heap of proxies, for example, or appointing a whole people as proxy if they're not going to be able to be used to be voted on at the meeting on the particular issue that's winding you up. Right. So, we'd say there's one thing that's never prohibited is lobbying. So people can lobby their lives away. And so now, particularly if you can do electronic voting, that's going to be a whole lot more effective than trying to get people to appoint you as a representative of in some form or description to go that way.
It happened to me, Frank, when I had a client who came to me and wanted me to be their proxy for a general meeting, and we said, "No, that's fine, but you do realise I won't be able to vote for the election." Oh, so needless to say, we figured out something else. So if you are the rep, so if you're one of these people, if you are the rep, the bottom line here is that you have responsibilities now, and you should not be taking them on unless you know what they are and you can actually carry them out. So if somebody says, "I want you to be my proxy," you don't just go, "Yeah, sure, no worries," and don't think about it. You actually need to know what that involves, because some of that responsibility, arguably all of that responsibility, comes onto you as well.
Well, and ideally you've got instructions.
Blindly. Yeah.
You've got instructions about what to happen. So again, when you come back to powers of attorney, for example, if you're one of the things you've got to do as a power of attorney in relation to financial matters is not act in a way that's inconsistent with what the person giving the attorney would do. So if my mum appoints me as her power of attorney and I know she's very much against cryptocurrency, I shouldn't go and spend all of her wealth on Bitcoin and hope it works out okay. And the same thing with these things. If you're appointed by someone to do something, be like a lawyer, be like a strata consultant, and get instructions as to what they want you to do.
Absolutely. A couple more quick takeouts, we reckon. If you're the committee, you do actually have some rights here. As we said with that representative example before, you are entitled to be satisfied of representative capacity. You are entitled to make sure that the instrument that's being lodged in to get somebody to be the representative is correct. So you're entitled to do that. But Frank, we don't think you've got a right to be vetting people otherwise,
No.
except for what the legislation says.
No, and it's not. It's one of those things where it's probably when we talk about at election time getting ID for voting, all that sort of stuff. We still haven't done it really at elections, and bodies corporate certainly don't have the right to say, "Prove to me that you are." There might be an application afterwards where that could be disproven, but there's no ID scanning on the way in, like going into a nightclub. Not that I do that anymore either.
Yeah. And of course, for everybody, seek legal advice if you're not sure, because so many disputes hinge upon whether the representation was right and correct in the first place, and particularly where the outcomes might be slim, or it's going to be a really contested motion or general meeting. And we have a question there, Frank, from Sid. Thanks, Sid. If I'm the owner and the director of a company that owns the management rights and the associated lots in the scheme, can I appoint a family member to be on the committee?
No. So the family member is going to be an associate. So this is one of the, well, there you go. Next week's webinar is on discrimination in strata. So you could suggest that there's a section of the legislation that discriminates against resident managers by preventing them from having a voting committee position by virtue of their ownership of the management rights. And that's what that is, Sid.
Yep.
Fair or unfair? Appeared in 2008 and hasn't gone yet.
Indeed. And one final point, that we talked about developers' power of attorney before. They can absolutely be dropped at the last minute because they are a reasonably separate kind of thing to consider. Gosh, we've covered a fair bit of ground today, and we got there in the end. Run a little bit over, but a good topic to get through, and obviously a few people have got a few queries about it. Thanks for that. Thanks very much, everybody, for watching. We always know that there are other things you could be doing, so we are very appreciative. And as Frank said, next week, discrimination in strata. The word discrimination is getting thrown around an awful lot lately. We're going to delve into what it actually means in a body corporate. Should be a good discussion, that one.
Yes, very much so, mate.
Yeah. But for this week, Frank, thank you.
Thank you, Chris. Thank you, everyone, for joining us, and see you next week.
See you all.
Bye.
Bye-bye.